Good evening, friends. Amongst us, we have Justice Sunil Thomas, a former judge from Kerala High Court. Before we embark upon the knowledge sharing process, first of all, congratulations to Justice Sunil Thomas on being appointed as a judicial member of the Central Administrative Tribunal. And we wish that the same way what his judicial journey and personal life and professional front, which has seen new benchmarks in his second innings, first as a lawyer and then as a judge. The third innings as a Central Administrative Member Judicial goes on well, and we are quite sacrosanct about that. As they say that coming events cast their shadows, we are quite sure that the events of knowledge sharing would continue. And when we congratulated Justice Sunil Thomas, the first reaction of his was that his knowledge sharing process towards the CLC, beyond CLC, would continue. And we have seen with Justice Sunil Thomas that he has shared his knowledge sharing on different issues and different perspectives of law. Today's session is joint tenancy, tenancy in commons, and tenancy by entireties. These all words, the interplay between as such, if you think as a common man, you find that probably there is some error, there's no difference as such. But as they say that the law consumes its whole judicial journey by the subtle differences of the expression of the word, by the pauses, the commas, the semicolons, and the full stop. But where the words itself are different, it has its different connotations, and legal processes and legal brains work in a different fashion and different mind. To understand all this, we would request Justice Sunil Thomas to share his knowledge. We are all waiting to lurch upon the knowledge being shared by him. Over to you, sir.
Thank you, Mr. Vikas. It's always a pleasure to be with all the members of CLC, because we are in the learning process. So this time I'm supposed to discuss with you a topic which is of much relevance, commonly used, and slightly confusing also. Joint tenancy, tenancy in common, and tenancy by entireties. Now, one of the basic concept of law of property, which we are all studied during our college days, is that there can never be a property without an owner. Clearly indicating that property should always vest with an owner. It can be a single owner or it can be owners. When the property is owned by more than one person, we call them jointly as co-owners. Now, what is meant by the concept of co-ownership? Co-ownership, we say that it is a case of concurrent ownership, concurrent possession, and concurrent enjoyment of property by more than one person. So that is the concept of co-ownership. In the co-ownership, each co-owner has a share over the entire property. Or here, only thing is that he can have the enjoyment of the entire property. The only difference in the case of a co-ownership property is that the individual portion of that property is not allotted to him, not separately demarcated, and it is not separately identifiable. So as long as the property remains as a co-ownership property, one can say that each co-owner has got a share over each grain of sand that constitute that land, or even each portion of that property. Under the English law, the concept of co-ownership takes in three distinct concepts. One is joint tenancy, the other one is tenancy in common, and the third one is tenancy by entireties, which is rather, I may say, is a loose word. I will deal with it separately, but that's not it's a distinct one, but not a very, very significant one. Essentially, we have to understand what is meant by a joint tenancy and what is meant by tenancy in common. Are they the same, or are they different, or how they differ from each other? tenancy, and I will also caution you that when you go through these legal terms, you will find a lot of other words being used. Joint ownership, common ownership, ownership in common, like that. All are loosely used words denoting either a joint tenancy or a tenancy in common. One thing I will caution you all is that don't confuse the term tenancy with the tenancy relationship that exists between a landlord and a tenant. It has absolutely nothing to do. It's a totally different concept from that of the tenancy arrangement between a landlord. Why we use the term tenancy? To denote a co-ownership property held jointly or commonly, is that it is based on the Latin word tenant, which means only to hold. So it derives from that word, not the landlord-tenant relationship. So keep it in your mind that the tenancy, joint tenancy and tenancy in common has absolutely nothing to do with the tenancy as we have in the case of a landlord-tenant relationship. Now you have to understand is that though the term tenancy in common or common tenancy and joint tenancy have got a lot of common features, fundamentally they are two distinct concepts, inherently distinct different concepts with regard to the nature of ownership, regarding the rights and duties consequential to the ownership, and they would vastly differ from each other in content as well as on its impact. Fundamentally, the terms joint tenancy and tenancy in common are different in not only in form and in substance. Just before venturing into the details of that concept in detail, I'll tell you the three important ingredients, three important rights that exist in the case of a co-ownership property. In the case of a co-ownership property, each co-owner has got an unlimited right of access to the common property held jointly by them. So that as long as the property remains as a co-ownership property, each co-owner has the right to access the entire land. We call it the right to unlimited right of access to the property. The second ingredient is that each co-owner is entitled to require or entitled to ask for the profits that are derived from, profits if any, derived from that property. The third aspect is that if one of the co-owner incurs expense for the maintenance of the property held in co-ownership with other co-owners, he is entitled to ask for the contribution towards the maintenance expenses. So these are the three important rights which a co-owner is entitled to enjoy. Right to unlimited access, right to ask for profit, right to require for the contribution of the expenses incurred for maintaining the property. Keep that in your mind. Now, regarding the concept of co-ownership, there are certain ingredients. Suppose A, B, C, and D purchase an item of property in 2020. We say that there is a unity in time, unity of time, because the co-ownership in relation to that property vis-a-vis each co-owner commences at the same point of time. So we say that there is a unity of time. The co-ownership has commenced at that time when they are jointly acquired the property. When we say that the property stands registered in the name of the three co-owners, the conclusion is that there is a unity of title. They jointly hold title over the property. If the property is jointly possessed by them, or jointly mortgaged by them, or they jointly enjoy the usufruct from the property, we call it, there is a unity of possession. Then the third one, last one is, each person has got an interest over the entire land. We say that there is a unity of interest. Now the question arises, when the property is jointly held by two persons, the question is it a joint ownership or a common ownership? Co-ownership can commence by several methods. After the death of an owner of a property, right devolves on his legal heirs. They jointly hold the property. 2 or 3 persons may jointly purchase an item of property. They jointly hold the property. One person sells his item of property to a group of persons. All of them jointly hold the property. In the case of a death of a tenant, the right devolves on his legal heirs. There is a devolution of tenancy in favor of the legal heirs of the tenants. So there is a co-ownership tenancy right. Question is, what type of rights are they? Do they come under the concept of tenancy in common or joint tenancy? Now, if you look at this concept in detail, what you will find is that the right of even though there may be unity of ownership, unity in possession, or unity in enjoyment of the property, the share of one person may differ from one instance to another. Now, how to distinguish between a joint tenancy and a tenancy in common? What are the salient features? What are the characteristics of those? As the term denotes, when 2 or more persons jointly hold a property, we call it a joint tenancy. When 2 or 3 persons, 2 or 3 co-owners hold the property in common, we call it tenancy in common. But still the question again comes, what exactly is the difference between tenancy in common and joint tenancy? The most important definition that I will tell you is that, or the most important, the distinguishing factor is that in a case wherein properties are held by persons jointly, the share of each co-owner may differ from person to person. Say, for example, 3 persons hold the property in co-ownership. Each may have an equivalent right over the property, 1/3, 1/3, and 1/3. Or it may be a case wherein one person has got 25% right over the property, another person, second person has got 50% right over the property, the third has got 25%, altogether making 100. So in every co-ownership property, the share of one co-owner may vary from 1 to 99 or even 100. Now, as I make it more clear, assume a situation wherein 3 persons jointly purchase a property and the term of assignment only says that we have jointly purchased the property. There is absolutely no indication as to what is the individual share held by each person. Assume a different situation wherein 3 persons purchase an item of property and they say that each will have equal right over the property or 1/3 share of the property. In the case of both, there is one distinct feature. That feature is that in the case of the first instance, which I told you, that 3 persons jointly purchase a property without specifying the share, it's a clear case of a joint property. Whereas, the second example which I told you, it is a case of a tenancy in common. In other words, in the first instance, each person has got entire right over the entire extent of land, and each person hold it jointly with the other person. The second is a case wherein 3 persons having equal share enjoy the property in common. In both instances, they enjoy the entire property till a physical partition is effected, till the co-ownership property is broken by metes and bounds and divided among the 3 persons, the co-owners. So so what is the significance of joint ownership? I think the significance is very clear. In the case of a joint ownership, the right of a co-owner is complete, or 100%. Each co-owner, we can say, is a joint owner, has got complete right over the property, and his right is not specified or limited. Whereas in the case of a co-ownership, the tenancy in common, the individual share of each co-owner is specified, though they can have a common enjoyment of the property. The common feature in both cases is that there may be a unity in title, there may be unity in possession, unity in enjoyment, but in the case of a common ownership, the share of each person is distinct, clear, and stipulated. Whereas in the case of a joint ownership, there is no such stipulation. So I told you initially that the concept of joint ownership and tenancy, joint tenancy and tenancy in common are substantially distinct and fundamentally different. Naturally, the consequence also follow. Though I have come across several decisions clarifying the distinction between joint tenancy and tenancy in common. One important decision which I may refer to your purpose is an Orissa decision, an comparatively old decision. It is Sridhar Goshe, Goshe versus Harimohan Sahu, AR 1964, Orissa 141. That's a decision where I found that the distinction between joint tenancy and tenancy in common have been very clearly narrated and made out. The first distinguishing feature between joint tenancy and tenancy in common is that the mode of creation of the right is different in both cases. Joint tenancy arises in cases wherein grant is made in favor of several persons and there is no word in the document creating the right indicating that the grantees are to take separate interest over the property. Or in other words, joint tenancy arises wherein right is created in favor of 2 or more persons without stipulating their separate share. Say, for example, 3 persons jointly purchasing an item property. The question is, what is the individual share of each person? As long as there is no indication in the purchase deed or the document by which the right is created, it can only remain as a joint tenancy. Whereas, when the grantees are directed by an assignment or by a document, grantees are directed to hold the property in moieties or in separate share. It's a case of tenancy in common. Say, for example, 3 persons purchase an item of property and the purchase deed stipulates that each will have 1/3 right over the property. It is not a case of joint tenancy, but it's a clear case of tenancy in common because the share of each person is clear and separate. But there is a unity of ownership, there is a unity of title, there is a unity of possession, there is a unity in time also. But in the first instance, the share is not stipulated, but whereas in the case of a tenancy in common, the share of each person is stipulated. As I told you earlier, it may vary from 1 to 99. Once it becomes 100% of each, as far as each person is concerned, it becomes a joint tenancy. So that the concept is totally different. 3 persons joint or 2 or more persons jointly holding a property and 3 persons having definite right to the property, enjoying the property in common. This is the distinction between tenancy in common and joint tenancy. Now, under the English law, the general principle is that unless there is a word of, we call it word of severance, unless there is a word of severance in the document, in the title deed, each co-ownership property will be deemed to be a joint ownership. Now, to decide whether property held by co-owners is joint or in common, we have to find out how the right is stipulated in the document. If there is any indication in the document by which their rights are created, by which the right of each person is sought to be severed from each other, under the English law, as I told you, it is a word of severance, by which rights are segregated, rights are separated, then we call it a tenancy in common. Father executing a settlement deed, stating that after my death, I hereby assign the property to be enjoyed by my children jointly. Share not determined. Naturally, all will have to enjoy the property jointly. Each can have a full access over the entire land. Each is entitled to have the share, enjoy the property, etc. But once a word of severance is indicated, clarified in the document, it becomes a tenancy in common. In the absence of any word of severance, the relation has to be deemed to be a case of tenancy in common. So that is the first important aspect of tenancy, of joint tenancy. And we say that the most expressive words used is that in a joint tenancy have one and same interest accruing from one and the same document of conveyance, commencing at one and the same time, and held by one and the same person having undivided possession of the property. This is how nicely the concept of joint tenancy is described. In a joint tenancy, joint tenants have one and the same interest over the property. All the joint holders have similar right over the entire property. It accrues to them from one and the same document. It commences at the same time, and it is held by all of them at the same and enjoy a same one and the same undivided possession of the property. This is the one of the most crucial distinct feature of joint tenancy and tenancy in common. That is, the mode of creation of rights is different. The second distinction is that joint tenancy can be created by act of parties and not by operation of law. Whereas tenancy in common can be created by operation of law also. I'll give you one typical example of, before that I'll just give you, so that a joint tenancy can be created by in a document, by a settlement deed, by a deed of conveyance, by executing a trust deed. One typical example of creation of a right of joint tenancy is contemplated under Section 76 of the Indian Trust Act. Indian Trust Act under Section 76 says that in case of death of one trustee, or he ceases to be entitled to continue as a trustee, the trust does not come to an end, but it continues continues in relation to the remaining trustees. So that is one important concept of joint tenancy, which distinguishes it from a tenancy in common. That is, joint tenancy can be created only by act of parties, whereas tenancy in common can be created by, and not by operation of law, whereas common tenancy can be created by operation of law also, apart from other methods of creation of it. The third important point that distinguishes a joint tenancy from from tenancy in common is the consequences that follow, the incidents that follow from this relation. Take the example of a tenancy in common. What happens if a co-owner dies? Can a co-owner assign his share to another person? And can that assignee get into this co-ownership relationship along with the remaining co-ownership? Now, the most distinguishing feature of joint tenancy is the concept of survivorship. What is meant by the concept of survivorship? In the case of a joint tenancy, I told you, the right of each co-owner is not stipulated, so that all the co-owners or the joint owners are holding the property jointly, having absolute right over the property or entire right over the whole property. So what happens when a co-owner in case of a joint tenancy dies? Will his share go to his legal heirs or to the other joint owners? I told you the concept is survivorship. Normally, a legal heir can succeed to the estate of a co-owner if that co-owner has got a distinct share over the property. In the case of a joint tenancy, since the joint holder has no stipulated right over the property, there is nothing worth to be succeeded to his legal heirs. So consequently, on death of a joint holder, his share will merge with the remaining rights of remaining joint holders. So if there are 3 persons holding joint tenancy, on death of one person, his share will, his right, not share, his right will merge with the remaining 2 persons. It is irrespective of, it is notwithstanding a will executed by the person who has expired. Even if he executes a will and says that the joint property, my right over the joint property will go to my legal heirs, notwithstanding that will, the property will completely vest with the remaining joint holders. So the remaining 2 persons, on the death of one among them, again the property will completely merge with the last surviving person. Then the question comes, on his death, what will happen? It's very clear. On his death, at the time of death, he has acquired 100% right over the whole property. So naturally, his share, that property will vest with his legal heirs. So this is the concept of survivorship. That is the most important ingredient of joint tenancy, which is absent in the case of tenancy in common. In tenancy in common, what happens is that on the death of a person holding the property, the co-owner, the right of that person, on the death of a will rest with the legal heirs of that person. It will not merge by survivorship, because the reason is that his share is distinct. The only difference is that the property remains as a co-ownership property. It has not been divided. It has not been physically demarcated and separated. Then another thing is, another consequential ingredient is that a co-owner, in the case of a tenancy in common, is entitled to assign his right, sell his right, mortgage his share, subject to the law applicable in the case of mortgages. In principle, it is possible. So that this is the most important distinction between the joint ownership, joint tenancy and tenancy in common. There is one more thing is that one more distinction feature is that in the case of tenancy in common, it can be commenced at different times. But in the case of a tenancy, joint tenancy, it can commence only at the same time by a same document, and it will continue till the remaining. So that these are the distinguishing features of joint tenancy and tenancy in common. The mode of origin is different. The method of creation is by act of party. In the case of joint tenancy, it is by act of parties and not by operation of law. Thirdly, the most important distinguishing feature of joint tenancy is that of principle of survivorship. On the death of a co-owner holding a joint tenancy, his right will merge with the survivors. Whereas in the case of a tenancy in common, his share will devolve upon his legal heirs as per the law of succession, or if he has executed a will, as per the law, as per the will. It will be a testamentary succession and not an interstate succession. So these are the important distinguishing characteristics of joint tenancy and tenancy in common. Now, is it possible to convert a joint tenancy to a common tenancy? Under the English law, a person holding joint tenancy is entitled to convert the relationship into a tenancy in common by giving notice to the remaining joint owners. Say, for example, if A, B, and C are jointly holding the property by joint tenancy, and if A wants to discontinue that relationship, he is entitled to give a notice to B and C, and thereupon the relation between A in vis-a-vis B and C jointly will be that of a tenancy in common. Naturally, all consequences will follow. So the same principle should continue in the case of Indian law also. Now we come to the next important topics. That is regarding the Hindu law, Nirakshara law, as well as the concept of joint tenancy, and also the Indian Succession Act. As I told you earlier, the concept under the English law is to presume that in a title deed, in the absence of a word of severance, or nothing, in the absence of anything to indicate that relationship should be tenancy in common, it will generally be deemed to be a joint tenancy. And this concept is accepted in the under the Indian Succession Act by virtue of Section 106 of the Indian Succession Act. So that under Section 106 of the Indian Succession Act, it says that in the case of a will executed by a Christian, Parsi, or a Muslim, or a person governed by the Indian Succession Act, in the absence of any term in the document, it will be deemed to be a case of joint tenancy. Section 106 says that in the absence of any stipulation to the contrary, the persons to whom the property is gifted or assigned under the Indian Succession Act can hold the property jointly. Thereby, the concept of joint tenancy is accepted under Section 106 of the Indian Succession Act. Now, what is the corresponding provision under the Hindu law? Under the Hindu law, there are a few decisions which I will refer to. The first decision is an old Privy Council decision, Jogeshwar Narayan Dev versus Ramchand Dutt. Jogeshwar Narayan Dev. Jogeshwar Narayan Dev versus Ramchand Dutt. 1923 Indian Appeal 37 Privy Council. That was the case wherein the question arose regarding the concept of joint tenancy under the Hindu law of succession. It was laid down by the Privy Council that the principle of joint tenancy is unknown to Hindu law, except in the case of a co-parcenary between the members of a Hindu undivided family. So that it was said that joint tenancy is unknown to the Hindu law, except in the case of a co-parcenary in a Hindu undivided family. This decision was followed in a subsequent Privy Council decision in the year 1933. That is in Ramcharan Das. Ramcharan Das versus Naurangi Lal, Naurangi, Naurangi Lal, AR 1933 Privy Council 72. AR 1933 Privy Council 72. In this case, the Privy Council reaffirmed the law laid down in Jogeshwar Narayan Rao's case. The same question came up before the Supreme Court in yet another decision in the year 1968. That is in B. Venkata Krishna Rao versus B. Satyavadi, AR 1968 Supreme Court 751. That was a case wherein a Hindu lady brought up 2 children as her foster sons. She was an unmarried woman. She executed a will by which her properties were bequeathed in favor of 2 children, 2 foster children. It was also provided that after the death of 2 foster children, the rights they can enjoy during lifetime. After them, the entire rights would devolve on the grandchildren. Grandchildren filed a civil suit for a declaration that all of them have acquired right equally over the property. So the question that came up before the trial court, which was considered up to the Supreme Court, was whether property was held by the legal heirs jointly or in common, whether it was a case of joint tenancy or in the case of a tenancy in common. Supreme Court followed the earlier 2 Privy Council decisions and held that joint tenancy was unknown to the Hindu law, except in the case of a co-parcenary between members of a Hindu undivided family. It was also provided that, it was also held by the Supreme Court that the testator in the testament did not indicate that each person, each child should take specific share. Property was bequeathed to them jointly. So the Supreme Court held, following the early 2 Privy Council decisions, that it has to be held to be a tenancy in common. There was no indication that it has to be held jointly. So that is the law. Whereas under Section 106 of the Indian Succession Act, it is specifically provided that the legacy will not lapse if one among the legatees dies, predeceases the testator. Or in other words, under Section 106 of the Indian Succession Act, if a person bequeaths the property in favor of 2 or more persons, and one among them dies or predeceases the testator, still it will continue. The property will vest with the remaining, will jointly. So that there is a concept of joint ownership recognized under Section 106 of the of the Indian Succession Act. So this is one important ingredient. Now the question will come. In many cases, the impact of a joint tenancy and tenancy in common have arisen. One important aspect is, in the case of a tenancy, in the case of death of a tenant, I refer to a tenancy in a landlord-tenant relationship. Suppose building is let out to a tenant, and during the existence of the tenancy relationship, the tenant dies. Naturally, the tenancy will devolve on the legal heirs. Are they holding the property jointly, or is it a case of tenancy in common? In several cases, this question has come up, especially in the background of because it's not much concerned whether they have got any joint tenancy or tenancy in common. The question is, suppose if notice of summons is served on one of the tenants, one of the legal heirs of the original tenant, that would amount to a complete service on others have come up. Incidentally, the courts were called upon to decide what is the status of the legal heirs of the tenant. Are they holding the property jointly, or they are holding the property in common along with the remaining persons? This has come up for consideration in few cases. I'll refer to that. One of the important decisions is in H.C. Pandey versus G.C. Paul, 1989, 3 SCC 77. The question came up whether the tenancy, on the death of the original tenant, whether the tenancy relationship, tenancy arrangement will devolve on its legal heirs as joint tenancy or tenancy in common. In this background, the Supreme Court held that the incidents of tenancy are the same as enjoyed by the original tenant. It's a single tenancy, and there is no division of premises, there is no division of relationship, there is no division of rent also. So that Supreme Court conceptually held that in the case of death of a tenant who has taken a building on rent, the tenancy relationship will devolve on the legal heirs, and they will hold it as a single unit jointly, and the relationship will be a joint tenancy, and not a tenancy in common. Because there cannot be a division of tenancy arrangement. There cannot be a division of the property. There cannot be a division of the rent also. This was the law that was laid out by the Supreme Court in H.C. Pandey versus G.C. Paul, P.A.U.L., 1989, 3 SCC 77. Subsequently, another bench of the Supreme Court ratified it in Harris-Tunton versus ADM. Harris-Tunton versus ADM, 1995 AR, SC 676. An ancillary question in relation to this relationship arose in subsequent few decisions. The question that was, which I referred to earlier, was on the death of a tenant who has taken a building on rent from the landlord. Two questions may arise. One, what is the relationship between, what is the nature of tenancy held by the legal heirs of the original tenant? I mentioned just now that these two Supreme Court decisions confirm that legal entities are holding the relationship as joint tenants, holding the tenancy right as joint tenants and not tenants in common. Ancillary question is, hence, if notice is served on one of the legal heirs, and if one of the legal heir of the original tenant is brought on record only, and notice is served on him, whether that will amount to a valid service of notice and a further consequential valid order of eviction in relation to other joint holders. The concept is very clear. They are holding the property as joint owners in joint tenancy. Based on that concept, the Supreme Court in few decisions held that even if since the legal heirs are holding in joint tenancy, each person has got a complete right over the entire land. And he represents others also. So unlike in the case of a tenancy in common, where each person is entitled to notice, and each person should be brought on record as the legal representative of the tenant, in the case of a joint tenancy, the Supreme Court held that notice on one joint holder, one tenant will amount, one legal heir will amount to notice on the remaining. I'll give you a few decisions on the same point, which has been consistently been followed by the Supreme Court. One is Buddh Sen, B-U-D-D-H, Buddh Sen versus Sheila Chandra Agarwal, AR 1978, Allahabad, page 88. AR 1978, Allahabad, page 88. It was held that in a joint tenancy, notice to one legal heir, one joint tenant will be sufficient, will be notice to the remaining tenants. The same was followed in by a Supreme Court decision in Suresh Kumar Kohli versus Ragesh Jain, 2018 AR SC 2708. AR 2018 SC 2708. AR 2018 SC 2708. The third decision is Badri Narayan Jha versus Rameshwar Dayal Singh, AR 1951 SC 186. AR 1951 SC 186. AR 1951 SC 186. And the last decision in that series is one which I referred to earlier, Harish Tandon versus ADM 1995 AR 1995 SC 676. So in all these decisions, the law was settled, was clear that a notice to one tenant holding as joint tenant consequent to the death of the original tenant in a tenancy arrangement will be sufficient, because notice to him will be deemed to be a notice to the remaining persons. So these are the important aspects of tenancy in common and joint tenancy. Initially, I had told you that there is one more concept of tenancy by entirety. Tenancy by entirety is a unique concept. It's a concept by which it's also a tenancy by which when a husband and wife jointly purchase the property, it will be deemed to be a tenancy by entirety. Suppose they purchase the property without mentioning that they have purchased it jointly or whether they are holding it in common, etc. Mere fact that it's a purchase by husband and wife, that will fall within a third concept recognized under the Indian English law and sparingly used in India also, denoted by the term tenancy by entirety. Virtually, it will be an instance of tenancy by joint tenancy. As long as the matrimonial relationship subsists, they will be holding it as joint tenancy. So each spouse has got 100% interest over the entire property and individual property over the property as if he is a full owner of the property. So 100% interest and an undivided interest over the whole property as if he is a full owner. Now it is considered as a case of joint tenancy. So these are the important aspects. Now before concluding, I will also tell you one more thing. Though Transfer of Property Act deals with this, the transfer of immobile property, this concept of joint tenancy is not specifically mentioned, referred to under any of the provisions of the Act, though there are two provisions which incidentally indicate co-ownership property. Or not incidentally, straight away, directly referred to the co-ownership property. That is Section 44 of the Transfer of Property Act and Section 45 of the Transfer of Property Act. Section 44 deals with transfer of co-ownership property, right of a co-owner to another person. Clearly, it can only be the case of a tenancy in common. It says that a co-owner is entitled to assign his right, transfer his right to another person, and the person to whom it is so assigned will acquire all the rights enjoyed by that person. And Section 44 has got one exception. The exception is that, as you all know, if the property held so assigned, a share assigned by a co-owner will not entitle the purchaser of the co-ownership right to claim residence along with the family residing in that property, an undivided family. His only remedy will be to seek for partition. 45 is regarding the sharing of the income. So Section 44 and Section 45 in toto refers to the transfers effected by co-owner. Substantially, these are the provisions relating to the co-ownership property, generally divided into tenancy by joint tenancy and tenancy in common. I hope these provisions will help you. And now the session is open for discussion. Any doubts? Anybody who has got any doubt, you can open it. I'll try to answer.
Yes, sir. One question is, can a landlord discriminate between some tenants by giving them an alternate accommodation and while the others are not being given?
Can the landlord
discriminate between the tenants To some, he gives an alternate accommodation to leave that premises, while to others they are not given. Whether
no, that depends on the question. Now, see, you will not that straight away affect. See, under the Rent Control Act, tenancy can. I'm referring to a tenancy under the Rent Control Act, governed by the Rent Control Act. He can be evicted on specified grounds only. One of the ground it can be alternate accommodation. The ground can only be reconstruction. Reconstruction will be permitted by the court only based on a condition that they will be accommodated again. So that it depends on what ground he asks for eviction. And if he discriminates without any valid reason, will it not affect the bona fides of the landlord himself? That will be too risky a proposition for the landlord.
Yeah. This is on the YouTube. Yes. So can one tenant by entirety be ostensible owner of the property if consideration is paid by one tenant and property is recorded in the name of other tenant?
No. He cannot be. Because that affects the landlord relationship. He cannot be the ostensible owner. I mean, a legal heir. Can that person clarify whether he refers to a legal heir of a tenant or the original tenant, a co-tenant? A person holding
can one tenant be in entirety be an ostensible owner of the property of if consideration is paid by one tenant and property is recorded in the name of other tenant?
No. The concept of ostensible owner will not apply. Because ostensible ownership under the Transfer of Property Act can arise only when one person is holding the property with the consent, express or implied consent of the owner. In the case of a tenancy arrangement, there cannot be an ostensible ownership because the tenant its a relation is that of a landlord and a tenant, and not as a purchaser, as the owner and the agent, which is the instance arising in the ostensible ownership.
This is Abhishek Bhatt. Is a property purchased by the Hindu husband and wife jointly be considered as a joint tenancy or tenancy by entirety?
It can only be a tenancy by entirety.
Okay.
Yes.
This is Veera. Two brothers purchase property under different sale deeds and build a house in the property jointly, single house. Can that be a joint tenancy?
Okay, can you please repeat the question?
Sir, two brothers purchase property under different sale deeds and build a house in the property jointly. Single house, can that be a joint tenancy?
No. No, it's a tenancy in common because two persons have purchased the property at two different points of time. Two different points of time. So that in the case of a joint tenancy, the most important aspect is that should commence at the same point of time, continue together, and there should be. Whereas in this case, two persons purchase two different properties, they hold it jointly, so it can only be a tenancy in common.
So before we end up, if we have to give a salient feature of a joint tenancy and tenancy in common, how do you how will you sum it up?
I'll clarify it by a single point. In the case of a tenancy, joint tenancy, the individual share of the person holding it is not stipulated. That means his share is not stipulated. Two persons jointly purchased it without mentioning what is the share. It's a clear case of joint tenancy. That's signifying where if the share of any person is indicated in the document of purchase or the title deed, it can only be a tenancy in common. This is the broad distinction. All the differences follow from that.
Is it last
is
question?
It clear? I think that I'm clear.
Shivam Trivedi, can a foreign citizen being a legal heir be included as a co-owner, and can he claim tenancy?
He is entitled to. He's entitled to, subject to the. I do not know whether there is he's from a country from which is not recognized. Otherwise, generally, I feel that there is nothing wrong in a foreigner acquiring the property. Only thing is that he has to get permission from the central government.
Right, sir. So thank you everyone who has stayed connected with us in this legal journey, sharing processes by persons of immense knowledge, like Justice Sunil Thomas. And we once again wish him all the best for the new journey which he is going to embark. And on Wednesday, we have a session by Justice Roshan Dalvi, a former judge. That is domestic violence, substantive law, and actual practice. Do stay connected with us at 9 p.m. Everyone stay safe, stay blessed. And we are just keep on receiving the messages. An awesome session and a brilliant session. Thank you.
Thank you.